All right, everyone. Good afternoon. Today is Thursday, December 12th, and this is the first meeting of the Policy Committee for the 24-25 school year. We have a number of policies that we're updating, recommending for updating based on the most recent PNN updates from the Pennsylvania School Boards Association around school code. And then we have a conversation about two items with an eye towards early 2025. So I'm going to just begin by sharing my screen, and I'll begin with the agenda. Go to, there we are. So for today's agenda, first we have this series of policies that are predominantly changes to school code, and then a few items that we'd like to ask for some changes that we feel are pretty straightforward. So I'm going to begin with policy 005, organization. This policy has a few very minor recommendations from PSBA, and they are based on expectations for how a school board member would be removed. And you can see here in pink where the recommended changes are in the policy. There has been a shift in terminology from board member to school director. So you see that at the front half of the policy. And then there are a few minor changes, in particular this sentence in bold, that officers of the board may only be removed from office during the designated term after receiving notification of the reason for removal and the opportunity for a hearing from the board, before the board in accordance with applicable law. All the rest of the notations you see are really terminology. And then you see appointees of the board may be removed in accordance with the terms of a contract or provisions of applicable law. The background on this, very briefly, is that some boards of school directors are more contentious than ours have historically been. And as a result, there's been some challenges to people being removed from office or removed from particular committee positions as election consequences have sort of folded out. And so while this isn't something that we have an immediate concern here in Springfield Township, the changes to policy will just protect the group as far as procedures when you want to make a change. So are there any questions about this change in terminology and how board members would be removed from office? Mr. Jordan?
Yes, so it does note a hearing. So is this a public hearing or is this just a meeting with the board members?
That's a great question. So opportunity for a hearing before the board would suggest a public meeting because it doesn't specifically say in executive session. So
All right,
yes, I would anticipate this being public.
yeah, thank you. Thank you very much.
Absolutely. Are there any other questions about this policy? Okay, all right, seeing none, I'm gonna move that forward to the January 7th meeting. We only need one reading for this policy because it is considered minor changes. So we'll be able to vote on this on the 7th and have it approved and move forward from there. So the next two policies are closely related. Policies 113.1 and 113.2. So I'll start with discipline of students with disabilities. Both of these policies, 113.1 and 113.2, the terminology that's suggested for change is related to changes in school code terminology. And so they are very minor changes. You'll see a few words here. Anything in bold is a change in language. But essentially, the existing policy for discipline of students with disabilities is unchanged in practice and procedure from what we currently have in place. Dr. Lutz, I know you've reviewed these policies, and Dr. Johnston, you're here as well. Is there anything in particular you feel it's important for the board members to take note of as they're reviewing this policy?
I would just recall back to our previous policy meeting earlier this fall where we made some language changes around like products instead of naming the product. These are akin to those changes.
Thank you, Dr. Lutz. Mrs. Aberly, I see your hand up.
Yeah, I just had
Dr.
one.
Aberly, sorry about that.
That's right, no worry. As I was reading this policy, and I think it appears in a couple of other ones, under the piece around referral for law enforcement and reporting. So as you have it on the screen at the moment, the sentence that starts the superintendent, right? As I was reading this is a really hard sentence to follow. It is basically a paragraph, but a sentence.
Oh, I see, at the
And
bottom.
in terms of like kind of making it like plain text English for, people just to generally understand, it is terribly hard to follow that sentence.
As a former English teacher, I don't disagree. There are a number of dependent clauses in this sentence.
Yes.
Yes.
It was just it was an observation. I'm guessing it's kind of like, that text that's like imported at, from the kind of like state level or whatever, but it's just very, very hard to follow.
It is. I would say that this follows the definition of legalese. You can see that there are quite a few citations that follow that paragraph. And so, yes, this is taken directly from state law and Pennsylvania state code. Where we really are implementing this policy would be through the administrative regulations. And I will say that, in general, this has been a fairly straightforward process for us, and thankfully rarely needs to be implemented. Dr. Lutz, is there anything you would say about that particular section?
I would agree. I think a lot of it is governed by our memorandum of understanding with the police department. And so we follow that very strictly to make sure that we're making reports when we need to.
Thank you. The other thing I'll say about these series of clauses, there have been multiple conversations at the state level around portal to portal and what exactly does portal to portal mean. And so I think there's an attempt here to define that in a way that can't be misinterpreted. Is that helpful?
Yeah, but I mean, I think you're right. It's like a legalese type thing that maybe your general public are not necessarily going to understand without some level of interpretation. But yeah, as I was reading that, I was like, holy moly, this is,
yes.
There's a lot of, and then if this, if that. Yeah.
Yes, it does feel like it could be a series of bullet points, doesn't it? Yes, understood. Mr. Jordan, did you have your hand up or were you lowering your hand from before?
Yeah, no, I was lowering my hand from before.
Okay, thank you. So absent the verbosity, is there agreement that this policy can move forward?
Yes.
Okay, thank you.
Yes.
And then the related policy is behavior support 113.2. And again, this is strictly to move into alignment with school code. There are very minor changes in this policy. So law enforcement agency is a change in terminology that you've seen repeated throughout the last year as we've been revising policies from police department, because they want to expand the definition to any law enforcement agency. Is there anything else about this policy that you have questions around?
I don't have any questions at this time. Thank you.
Okay. And again, we feel like the implementation of this policy has been very straightforward. It's been easy for us to implement. Okay. All right. So I'm going to then move back to the agenda. And so the next policy, 202 non-resident students and 236 threat assessment. I'm going to ask Dr. Lutz to provide those summaries. I'll bring up the policies. So 202.
Non-resident. Oh.
Yes, I'm trying to get to my, I'm sorry, I'm having trouble moving my, there it is. Oh, eligibility, there it is. Sorry about that. There we go.
Thank you. So over the summer, months, and then leading into the beginning of this school year, the Pennsylvania legislature has made some changes to how we classify and need to provide notification to non-resident students. So this policy is now updated to reflect those legal changes. It does require that should we investigate or be informed that a student is no longer living in the district, we need to notify the parent of their need to withdraw due to non-residency, but we also have to offer a hearing as part of a remedy prior to being able to disenroll students. And this is so that students aren't kind of hanging out there with no school in which they're enrolled. Our students are allowed to remain in the district through the entirety of that hearing, and then if there are any appeals. And so we would work closely with our attorneys to make sure we carry this out. Other than that, all of the other changes in this policy that we made last April are going to remain in effect. As a district, we do not accept tuition students, but students in the 12th grade have the option to remain enrolled in Springfield Township if their family moves. That's under limited circumstances during their senior year, if they had already been enrolled here with us, so that they can continue on and receive their diploma with their classmates.
Thank you, Dr. Lutz. Are there any questions about these most recent revisions to policy 202? Mr. Jordan?
Yeah, so, well, my question is more so in terms of the implementation. Is there a time frame for this hearing? Like, how long? Yeah.
Sure. So once we notify families that we have come to the understanding that they no longer reside in the district, we send out a letter that provides them 15 days to respond to us, to let us know that they would like to move forward with a hearing. If they do so, we then work with our attorneys to schedule a hearing as quickly as possible. So that depends on our attorney's availability, getting a hearing officer who is also an attorney. So typically between 5 to 10 days. From that hearing, the hearing officer would then render a decision, which can take about a week. And then, like I said, the families have the opportunity to withdraw. So we're typically talking, from start to finish, from the letter to possible appeals process, maybe 3 months in total that students would be here enrolled in the district. When families get that letter, they do have the option to just withdraw with no hearing. And so some of our families that have received that letter have chosen to do that.
Okay, thank you. Thank you very much.
Are there any other questions about this policy? Okay, so we'll move that forward. And again, thus far, all the policies would be a one read and then adopted on the 7th in theory, and then effective that date. So the second policy that Dr. Lutz is going to speak a little bit about is 236.1, threat assessment.
So we have done some work with this policy fairly recently, but these are the updates that bring us into compliance with Act 55, which is an act that went into effect over our time actually out of school during the pandemic. But there's been several years of implementation of parts of these. We're very fortunate here in Springfield Township. We've already been doing a lot of the things that were codified in Act 55. So for instance, it requires the appointment of a threat assessment team in each building. We already have those. That's our clinical team. So our counselors, our social workers, our administrators, and our psychologists all are part of that threat assessment team. They are required to be trained annually. And so we always have options for that, both on site and also the MCIU offers some programs for our teams to take advantage of. And then this really helps to determine how our teams are going to respond respond to those threats. Something new that we will be doing is each year, Dr. Yannicone invites myself and Mr. Chinta, our supervisor of campus security, to come and share out during an exam committee on our Safe Schools report. Part of that report now will include the threat assessments report, so that we can share about that. And then also students experiencing homelessness, foster care, or other educational instability. We'll be making that presentation so that you'll receive that information.
Thank you, Dr. Lutz. Are there any questions about this policy? Okay. All right, so I'm going to then move forward in the agenda. The next two policies, Ms. Kerr, our Director of Human Resources, has reviewed, and so I'll go to 308 first and then 317. So let me just move down here. Okay, Ms. Kerr.
So this policy was in place before, and certainly the resignation guidelines that are indicated here is what we were following already. PSBA is basically just recommending that we add the guidelines into a policy. And it's just basically defining someone resigning from their position, giving us prior notice. And that it needs to comply with all contracts. Professional employees by school code have to give us at least 60 days notice. And then there's about certificated administrative and support employees should resign in accordance with their contract, compensation plan, board policy. And they had in here giving at least 2 weeks notice. There are times where we don't even want to accept 2 weeks notice. So I just made it that it was preferred if they give us 2 weeks notice. And then it also talks about the superintendent and assistant superintendent resigning from their position, that it should be submitted to the board president. But it's everything we were already doing.
Are there any questions about this policy?
No, not from me.
So I do believe this policy would require 2 readings as a new policy, but even it's been come out of the AR, but even so, I think we should probably do 2 readings in January and then have it adopted on the 21st. That makes sense to all of you. And then the second was not actually in the PNN, but Ms. Kerr brought this forward, and I think rightly so, with some recommended changes. So you want to describe those, please?
Sure. So as part of, it was called Act 24 that was put in place, I think back in 2017, I'd have to check the year, but not important. Employees had to, by law, fill out a form, everyone who was actively employed then, reporting any arrests or convictions of a certain type. So it was limited. It was not every arrest or conviction. If they were ever arrested or convicted of certain offenses having to deal with children, aggravated assault, DUI was on there, but it wasn't until the second DUI that happened within a 5-year period. Felony charges of a first, second, and third degree, misdemeanors of a first degree only. Summary offenses did not have to be reported. So there were limitations on what had to be reported. And that is described in this policy. But what we have come to find out, Dr. Yannicone, in another law under the Educator Discipline Act, is required to report all arrests or convictions. There's no limitation on the arrests or convictions that have to be reported to the state that she becomes aware of. So there are times where people are arrested and they don't have to report it to us under Act 24, but she really is supposed to be reporting all of them to the state. And there's also times where people are arrested of things that they didn't have to report to us by law, but still can be a little bit of a PR nightmare for the district that we would really like to be notified of ahead of time prior to being, so we're not reactive and we can be proactive about the situation. So what this policy change is basically saying that employees have to use the form and they have to report to us all arrests or convictions, not just the ones that they're required to under law. So that we can really be proactive about any situations that maybe the public finds out about that maybe we didn't know about. Any questions?
No questions for me at this time. Thank you.
So we would consider this a minor change, and as a result, this would be a one read on the 7th. Sound okay?
Yes, that's acceptable to me. Thank you.
Thank you. All right, thanks, Ms. Kerr. Appreciate that work. Okay, and then the last two in this section are student activities and opioid antagonists, a brand new title. So first of all, for 618, let me go there. So this is a request. This was not in the PNN, but this is something that Ms. Green and I discussed. We've been talking about the establishment of student activity funds for various clubs and activities district-wide. And in the current policy, the board has to approve the establishment of each individual activity fund. It seemed cumbersome from Ms. Green's and my perspective that the board would have to do that, and that we would only be able to open a fund at the time of a board meeting. And so the thought was that you could transfer that responsibility to me. I would continue to follow all of our established procedures for opening student activity funds. They would continue to be managed per the policies we already have in place, but rather than have that be a board responsibility, it would switch to me. Are there any questions about making that shift?
Yes, I do have a question.
Okay, Ari, absolutely.
So when it comes to the approval, is it just the approval for creating it or the approval for modifying the funds as well?
Just the approval for creating it. So there are very strict guidelines for any modification of any student activity funds, and all of that comes out of Ms. Green's office. So she follows state and federal law and school code with regard to the management of student activity funds.
All right, thank you.
Absolutely. Are there any other questions?
My question is kind of related, and that's regarding the budget. So if we're creating a fund and it's be funded, how is that going to be appropriated within the current school budget? Because, we have a budget, it's kind of solidified. How is that then funded?
Yeah, this is a conversation. It's a great question. And it's a conversation that Ms. Kerr and Ms. Green and I actually are undergoing this year. We're looking to better define the kinds of clubs and activities that we have. For example, we have clubs where we do not provide any funding. They are self-sustaining clubs. The students do fundraising. They deposit the funds into the student activity account. They withdraw from that account when they need funds for various activities. And essentially, we are just the bank for that particular activity. There are other student activities that are school-sponsored where we do provide funding. So an example of that might be the theater program. So there's a student activity fund in existence, and we also provide funding. So Ms. Kerr and Ms. Green are actually working on an updated document that we will be able to share with our staff members at 3 of our schools, because we have clubs at least 3 of our schools, where we'll help them to understand what is and is not school sponsored, virtually, only a student activity fund that we're able to house for them and manage for students, or something for which we cannot provide, we can't be the bank. And so, for example, a booster club, we're not the bank for booster clubs. They have their own funding funds in other locations and other depositories other than the district. Does that answer your question?
Yes, thank you. Thank you very much. Appreciate it.
You got it, absolutely.
All right.
Yeah, we do try as much as possible to say yes when students are interested in new clubs or activities, but we also try to make sure that we are within the established budget, because obviously if we add something, we need to come back and share with all of you why we have gone over budget.
Yeah, correct. Thank you. Thank you very much. Appreciate it.
No problem at all. Are there any other questions about this change? Okay, all right, so I'm going to move from that, and that'll be a one read as well. And then the last policy, opioid antagonist, 823, is strictly based on a change of language at the code, at school code. And it's because they do not want us using the term naloxone. I have such a hard time saying this word, which is the traditionally used opioid antagonist. But because there are other vendors for antagonizing opioids, they decided to change that term. And so you can see here in multiple locations, they have asked us to shift from naloxone. Did I do okay, Dr. Lutz? I think that, to opioid antagonist.
Yeah, naloxone's the brand name, so that makes complete sense. Yeah.
Yeah, they don't want us, I guess they don't want us to be favoring one, although you do still see it here, including naloxone hydrochloride, right? Are there any other questions? This is a very, obviously a minor change, is terminology. There's no change in the policy other than that.
No questions for me. Thank you.
No.
Okay. All righty. So I am going to stop sharing my screen, and we're going to talk for a minute about, let me see if I can do that. Go. We're going to talk for a few minutes about the other agenda item today, which is a series of policies that we are wanting to remind the board about and see if there's any other direction the board would like as we prepare for the next presidential administration. There have been a number of public statements made by President-elect Trump, as well as members of his incoming cabinet, with regard to several matters for which the district has a history. And we want to make sure that we're following the board's guidance in these matters. So the first is related to immigration status of students and families, and the way in which the district will operate following the inauguration of President Trump on the 20th. And with that immigration status, there are several policies that may be affected. One is policy 204, attendance. The second is policy 251, related to students experiencing homelessness, foster care, or educational instability. And in each of those two policies, currently there is nothing that specifically states how the district will respond if law enforcement officials attempt to intercept a student, a family member, or a staff member while on school grounds. Historically, the federal government has, and up to this point, the federal government has made it against federal law to ask the immigration status of any student, family member, or staff member. There are some documents, and Ms. Kerr could share some information about that related to staff members and work status. But currently, we do not, we're not actively involved in the immigration status of our staff or our students. Looking ahead to the next administration, there is anticipation or expectation that there could be changes to federal law around this matter. And so many school districts are currently consulting with school district solicitors, and we are doing that. I have been doing that with our solicitor for several weeks now, to try to get some legal guidance on what we could or would want to do as a district in order to support our students with varied immigration status. In particular, I'm going to speak to our students. And so I'd love to hear from board members whether or not there's anything in particular that you want us to pursue or avoid in getting prepared for the next administration. Some of the things that are being discussed among school district superintendents in the area are potentially requiring a judicial warrant rather than a standard warrant if a member of ICE or another law enforcement agency would seek to take custody of a student on school grounds, off a school bus, at a bus stop, at an athletic event, at a theater event, etc. And so some recommendations by solicitors to school district administrators are that you may choose to modify policy or to add language to policy that would require a judicial warrant, which would be a higher threshold. Secondarily, with policy 251, we could also share information with regard to how our school board wants us to respond through an MOU with the police regarding the way in which law enforcement will interact with families and how we might notify other guardians or other agencies if we come to be aware of a family for whom, for example, parents are taken into custody and children need another form of guardianship or support, either in emergency or for some longer period of time. And then lastly, beyond policy 204 and 251, there are some school districts that are considering adopting a resolution for establishing the school district as a sanctuary school district. The Philadelphia School District currently is one such district. And in those cases, the resolution would, and I can provide that to the board committee at an upcoming meeting, that resolution would clearly outline our stance as a district in not being willing. We would certainly not violate federal law, but we would do everything in our legal power to support current students and families in continuing to avail themselves of a free and appropriate public education in our school district. So this is not something that is an urgent, immediate policy question, but it is one that we do anticipate potentially coming forward in 2025, perhaps as early as January 21st. So would love to have some feedback from the three of you with regard to how you'd like us to think about this or proceed.
Okay, well, I'll go first.
Sure. Appreciate that.
So I guess my question, and that is back to you in terms of, I don't know necessarily that we have to proactively look for procedures and/or policies to guard against that at this time. I think that inherently, I don't think that necessarily they would look to go after students. Now, to the second point that you have in regards to, maybe going after parents and then we need emergency care for these children, I think that maybe we need to look at perhaps putting procedures and or guidelines in place for events like that. I mean, that's just my opinion. Until something actually, gets drafted and or, they're looking to change policy, because I guess they want to do it more so through executive order than go through legislation. If we see something coming that way, then maybe we would have to adjust and perhaps put policies in place. But generally speaking, I don't know necessarily that we have to look to procedurally do anything at this time. That's my opinion. But if you have, if you think differently, please let me know.
Thank you, Mr. Jordan. Yeah, right now, all conversations are really speculative, and we do understand that because nothing's changed at this point. Dr. Lutz and I met with all of our multilingual language teachers last week, as well as our social worker lead, just to sort of have conversation about what are the established existing rights for students. Do we need to provide reminders to anyone with regard to that? And how can we make sure that we maintain safe and orderly schools with minimal, obviously we try to minimize any sort of incidents occurring on school grounds in order to keep kids feeling safe and supported in coming to school. We have a long history of working for a sense of belonging for all students. We certainly want to continue that within the bounds of the law. We also provided those reminders with regard to current established rights and expectations to our administrators. And so at this point, we're really just trying to provide education and sort of brainstorm about what might be some scenarios that we can encounter and how would we want to act in those scenarios. So I agree with you. We're not, our intention is not to be in any way alarmist, but to be proactive and prepared to the extent we can.
And I guess, you know, the other piece is like what existing policies we have that, you know, supplement that, like thinking about FAPE. I know you talked about the memorandum of understanding between us and the township police. And I know that you were planning some bolstering discussion around that memorandum of understanding as well. So, you know, just thinking about the other tools we have in our toolbox without necessarily going and upgrading or developing a new policy, what do we already have that, you know, strengthens any discussion, or, you know, somebody shows up and these are the policies we already have in place, and just really looking at the gaps that we may have there, you know, just trying to understand, you know, I guess preemptively where we may see, whether it's students, whether it's staff, whether it's supporting staff, are we covered for, you know, school property as well as, like you said, bus stops, transportation. Just really, I think, you know, if we can be like, try and be a bit preemptive about what we already have and where we may see some gaps, I think that would be helpful guidance for the board.
We can certainly do that. And we are looking at these potential scenarios. The MOU, the Memorandum of Understanding with the Springfield Township Police Department, is renewed every other year. We are due for renewal in June of 2025. And we will be beginning our internal review right after the holidays. And then we'll be meeting with the Springfield Township Police. And we've always had good engagement with them on that Memorandum of Understanding. And we will include this topic in that discussion. And that will, our intention is to have that ready for board review and approval in the early spring. That's our hope, depending on how quickly we can move through these items. And it is always eligible for revision, but currently we're in an existing MOU that's working pretty well for us at this point. Mrs. Hubley?
Yeah, I would just add, I think it's important to kind of align ourselves with the other area school districts and what they're thinking about doing. And to continue to just keep like following the guidance of our solicitor, you know, that's what, you know, I agree with what Lee said, just to make sure that we're making sure we're doing the right thing and being prepared, but also just, I think, just kind of continuing those conversations and seeing what other people's thoughts are. You know, I know you talked about Philadelphia, and while that's in a neighboring school district, I think it's very different from our school district, where I feel like some of the other area ones are a little bit more similar. So that would be my thoughts.
I appreciate that. And actually, this conversation has initiated post-Thanksgiving among the Montgomery County superintendents. And we are getting guidance from Fox, from our solicitor's office. We're fortunate in that Fox actually has an immigration department. And so they have been providing over the last few weeks continued guidance. And there's also a number of articles guiding school districts out of Education Week, based on some of the most recent statements and potential guidance. For example, there was a recent interview in which President-elect Trump shared the same view as Mr. Homan, the incoming director, around the idea that there have historically been safe zones, and those safe zones were hospitals, schools, and churches. And they believe that those safe zones should be disbanded. In other words, they don't believe they should be classified as safe zones any longer. And so that's part of the reason why school districts are starting to take a look at this possibility for changes. So I want you to know that we will continue to stay abreast of both the legal guidance as well as county conversations. We'll keep the board informed. If we feel at some point we do need to make policy change or recommendation, we'll absolutely bring it to the three of you. And then Brandon, Ari, from a student perspective, is there anything you think we may not be thinking about that you want us to think about?
One major thing, thinking back to a couple years ago, this was 2 years ago when there were a few unfortunate losses of life in the district. It's if there were to be someone arrested at a school function, there would be massive mental health effects on the rest of the student body, because it's terrifying. It's almost close, in my opinion, almost as traumatic for the rest of the student body as a death in the district, because it's somebody who is being taken away from their friends and being forced back oftentimes to a place that they haven't been for months, years, or maybe even never at all in the case of dreamers, or not since they were babies.
I appreciate
So
it, Ari, and I think that's when I made the statement about we want school to feel safe and students to feel safe and supported. Exactly what you're describing is what we will work to avoid. We do believe that schools should feel safe and comfortable for all students, regardless of immigration status. And we do recognize that the peer group would absolutely be traumatized by that experience as well. So I appreciate that input. Brenda, was there anything you wanted to add?
I was just gonna say something similar about how, like, if a student were to get like ICE were to come, I feel like it would just like take a big like impact on students' like mental health, and it would just be a really like difficult like situation to be in, and it would probably be like hard to be in that place and it wouldn't feel as safe as it was before.
Thank you. That's exactly what we're trying to avoid, and I appreciate the input from both of you, because obviously it would be students who would be experiencing that firsthand. Mrs. Haberly or Dr. Haberly, did you want to?
Yeah, I just have one, and not to derail from the immigration aspect, but there are lots of speculations about things that may change under a new administration, including things like teaching of religion in school, funding for education, special education in general. So I think there's possibly like you could spin your wheels like really worrying about a lot of these things, and we may or we may not experience some of these that cover these topics. So I guess it's like, really, where is that focus, right? Are we mainly concerned about immigration? Is that the thing that seems to be the most that's bubbling under from a maybe at the county level, or are there other things as well that we maybe need to think about in addition?
You're providing a terrific transition. And so, no, it's true. Anytime, and I want to be clear, anytime there is a change of administration with anticipated changes in policy, we do our best to prepare whatever those changes might be. And we try really hard to just be stepwise about, this is what we understand may occur, and here's how we as a district may choose to prepare or respond. And so there is another policy that we did take a review of, and that's policy 253, focused on transgender and gender nonconforming youth. And then I'll also speak after this about the U.S. Department of Education, even though we've actually been talking about that in finance, but I'll raise that because you've raised that comment. So I just wanted you to know there are no recommended changes to policy 253, but I thought it was important that the policy committee at least have an awareness of the fact that we have an existing policy. It's been in place since 2017. We did update and revise that policy as part of our overhaul of all policy in the last few years. The policy very clearly states that all students may use restrooms that align with their gender identity, and all students may participate in student activities aligned to their gender identity, including athletics. And so there have been some statements at the national level about possible changes, potentially a revocation of Title IX 2024 to go back to Title IX 2020. And we've talked about Title IX. We reviewed that policy in August. And so just wanted you to know that we are cognizant of the fact that there have been some statements at the national level, and that we do have a board policy that we do intend to continue to implement and enforce for our students, pending anything from the federal government that would make it illegal for us to do so. Are there any questions about policy 253?
I actually do have one.
Okay.
So under where it has the section on interscholastic competitive sports teams,
Yes.
how do we handle a situation where we go to a neighbouring school district, maybe one further away, and they don't have those provisions in place for students because they have a different policy or a different approach? So thinking about, like, you know, changing rooms, access to bathrooms, that type of thing. How do we handle that? Because that's not within our control, right? So
it's a great question. So we are very fortunate in this region in that overwhelmingly our policy is consistent with other school districts' policies and our competitors within and outside of the league. Where we, I'm not aware, quite frankly, of a situation that we've run into in a school district where we didn't have access to facilities that were appropriate for a student. But obviously we don't, other than when parents first enroll their children and identify or choose not to identify a gender in their enrollment, we don't in any way manage that. We allow the students to participate. And we have a number of co-ed teams as well, because under Title IX, students can participate in an athletic program opposite their gender if there isn't a program for their gender. For example, students who identify as female can participate in football because we don't have a girls' football team. And in theory, boys who want to participate in field hockey can do so because we don't have a boys' field hockey team. We've had very limited exposure to that, but I recall as a high school principal having a student, an international student for a year, and over in Europe, there are very many boys' field hockey teams. And so we had a young man at my former high school who wanted to play field hockey, so he did. And so as long as we are following Title IX, we do our very best to provide those supportive services for students. And to my knowledge, in my tenure here, we haven't had a single incident related to gender or around interscholastic athletics or restrooms. So far so good, but I do know that it was a talking point during the election, and certainly is something that is continuing to be a talking point at the federal level. And so we're not recommending any changes. We don't anticipate any changes, but did want to see if the board had anything else that you wanted us to do in relation to this policy. And then for our students, is there anything you would like to have us consider or think about or comment on?
I think our current policies are good as long as we continue upholding them in the case of any other outside policy changes.
Thank you, Ari. Appreciate that. And Brent, I saw you shake your head. No, you're good. And so I'll just shift to, based on Dr. Aberley's comment, we have also at Finance, we have shared with the board committee all the dollars that come from the federal government. And while these aren't specifically policy matters, we have looked at if there are changes to the U.S. Department of Education and funding streams, or if funding is reduced, how might we react as a school district? And we are prepared, because we are very fortunate to have a healthy fund balance, to manage the finances of the district, continue to make sure that students receiving Title I reading services continue to receive those services, continue to make sure that students receiving services under IDEA continue to receive those services. There have been some statements around reduction in federal dollars if districts are providing DEI curriculum. And we have a long history in the district of providing various forms of DEI curriculum and professional learning. And unless something drastic were to change in the district, I believe you would like us to continue to do so as a board. And so we did provide to the Finance Committee an overview of where our funding streams are. We receive approximately $1.4 million annually in federal from the U.S. Department of Education, from federal sources, and it's predominantly used to support Title I reading and special education services. And so it's our intention to continue to provide both of those services, unless and until somebody tells us it's against the law to do so. Are there any other questions or comments about where we are with regard to board policy on any of these matters?
No.
Go on,
I'm sorry, go
Sean.
ahead.
No, go, Sean. You go first.
I think that in terms of if they're looking to reduce and or cut federal funding, it'd be my opinion, and of course we would all vote to we find resources and other ways to continue what we can do. In terms of the immigration policies, I would think, I still think there'll be the regulation and or executive order that they would have to come down. There'd probably be some legal challenges going along with that, but then we will adjust. I think we will adjust accordingly to make certain that our students are safe and and well cared for. I can't see I will not look forward to ICE deciding to knock on the school and any school door to remove a student. So I would hope that they would use discretion when doing such, if it comes to pass. But I think that it's going to be challenges along the way, and that's from a legal standpoint. So that's my opinion. But
thank you, I appreciate that. Dr. Aberle?
Yeah, no, and I agree with Sean. I think I think the other piece is, depending on what comes to pass, just making sure that the community is really well informed about, if we were to lose federal funding, right, what does that mean? How does that translate down? Because I think it's making that connection with, these are the decisions that we make as a community in terms of who we elect, who we want to have in charge at whatever level, and how that translates down to you as a parent, as an educator, so that it's really clear to people the choices matter.
Absolutely, thank you. Mrs. Hubley, anything else for the group?
My only question was, if you had to use your fund balance, would you be able to do that for the 4 years of this?
Well, in theory, again, the federal dollars we're currently receiving are approximately 1.4 million, and we have a fund balance currently of in excess of 20 million.
Okay.
So yes.
My question was, could you last 4 years?
And probably by the time this happens, 4 years now is it takes 2 years for it to happen.
so we're looking like 6 years. Yeah, we're looking like 6 years.
Yeah.
If it were
I think, as Mr. Jordan shared, there will be legal challenges to any changes. Our primary goal, as you know, is to do everything we can, as Mr. Jordan said, to make sure that our students are safe and supported to the extent feasible and legally allowable. And so we'll continue to do that, and we'll continue to make recommendations for any policy changes if we feel they're appropriate and timely at any point. And we appreciate your support and your student-centered focus. Is there anything else from anybody on the committee? And which of you would like to make this board report on January 7th? Who wants a little homework over the break?
I'm happy to volunteer. But as I always say, if there's somebody else who wants their voice heard, I'm also happy to step back, but I'm happy to do it if you need me to.
I did have one thing I wanted to mention, not relating to the report. Please don't give me any more homework.
Of course. Sounds good. All right. It would be one of the board members, so I appreciate that. But what question? So Amy, we'll go with you. At this point, we'll make sure you all have the minutes and any other resources between now and then. All right. What question do you have?
So I know that there was a lot of interest in both the community and among the student body in what kinds of environmental and sustainability policies we have. And if we don't have one, or if we're still developing one, what kind either we have or what kind of input we can put into it as it's being made. That's coming from both the Sustainability Club in the high school and
Yes.
from the EAC in the district and the township.
In the township, yeah. It's a great question, Ari. Off the top of my head, I can't think of a specific policy, but if you wouldn't mind, just send me a quick email articulating the question. I will work on gathering some information for you. And I'll also share it with Joy, our representative at the township. I'll be happy to do so. She and I connect pretty regularly. And then you can share it with the students, both at our next advisory as well as the groups that you're a part of with the Sustainability Club. And we'll see if there's anything you all think might be missing. And then I can also have our team here take a look at Pennsylvania School Board Association to see whether or not there's any recommended policies. And we can bring that to the next meeting.
Perfect. Thank you so much.
You're welcome. Dr. Aberley, I see your hand up.
Yeah, I had a question on one of the other new policies. I think it's or an update to a policy, the attendance policy. So I think there is a section in there that talks about special needs and accommodation, and it specifically calls out the Director of Special Education, but I don't believe we actually have anybody with that specific title anymore. So maybe it needs to be Director of Special Education or equivalent, or I don't know how hung up people get on their actual specific titles. I come from like an area of business where it's very regulated, and if you don't have that person, then you're kind of in a spot of bother if somebody specifically asks that. So I don't know how restrictive it is, but because we don't have a Director of Special Education per se anymore, right?
We have a Director of Student Services,
Yeah,
who effectively is the Director of Special Education. But yes, I think it's a good good
I don't know
question.
if it's like, again, if it's like a legalese type thing.
Yeah, let me take a look at that. We'll take a look at policy 204.
Yeah.
See where that reference is made. And if we need to make a revision, we can bring that to the next meeting.
The other one I had is one that I contacted you about a little while ago, which is 824, around the definition of adult and how that applies to students in district that work for the school, and how that's interpreted if you're working for the school and you're a student of student age, but you're not actually in the school district.
I recall the question, and Ms. Carey, you and I discussed this. I have to go back in my memory about it, but it's policy 824. Let me try to bring that up. That's going to be in the live policies. Let me
Yeah, because it talks about school age students that are compensated by the school districts. And I think about this in terms of like the lifeguards, for example. There's a lot of school age lifeguards, and some of them are in district students and some of them are not. And so a lot of those provisions that are in there, like you can't text, like if you work for the school district, you can't text people, but you can if you're a student that's employed by the district.
So I'm going to find the paragraph, the phrase you're looking for. I pulled up 824 here. And just looking. So I'm looking under guidelines, and we're saying adults and guidelines, boundaries.
So I think there was a provision in there to call out people that were school age. Let me see.
I'm sorry, I'm just reading through and looking.
Yeah.
If it helps, I know that there is a feature often where if you press Control F, you can search for specific words.
Oh, let's see.
Yeah, so at the top of the policy under authority, the first paragraph, the last sentence says, the term adults as used in this policy does not include district students who perform services on a
There you go.
volunteer or compensated basis.
But this was about school-aged, essentially students, but they're not students in the school district. So what about if they're not in the school district?
I'm looking for the sentence that Emily just referred to. Tell me again, Emily, where are
The
you?
first paragraph,
Yep, this policy applies.
the second sentence.
The term adults does not include district students.
Who
So we could
perform
change it from
services?
district students to district or other students or students of school age.
Mhm.
So we can make a minor change there because your concern is that if they're not attending, if they're not attending district schools, they could be included in the policy.
Correct.
I understand.
Yeah.
Okay.
Yeah, because they could. I have this very specific example. So a school age person who is being compensated by the school for a job like lifeguard, but they don't go to school in the district.
Yes. So we can modify that sentence sufficient to and bring that on the 7th because that's a very minor change.
Yeah.
In language in order to clarify that, because I think the intention of the authority is indeed to keep
students and
yes.
adults separate. But
Correct.
Yeah, I think it's that district piece that kind of trips it up.
Yes. Okay, we can take care of that and bring it forward on the 7th.
Thank you.
Yeah, of course. Okay, I'll stop share. Anything else? Okay. Well, I appreciate everyone's attention. This will be our last meeting of 2024. And our next meeting will be pending any updates that we receive through the winter and would be like in early spring. If we need to meet sooner, we certainly will bring the team together. But I'm going to be optimistic and say we'll see you in something like March.
Okay. Well,
okay.
Yes. Well, thank you very much, Dr. Yannicone, for your continued support and oversight over the school district. We greatly appreciate your efforts. So,
thank you, Mr. Jordan. I appreciate it. All right, everyone. Have a wonderful winter break. We'll see you in the new year.